The first time the HOA president parked on my lawn, I thought it was a mistake. The second time I left a polite note. The third time she laughed and told me, "You don't really own that strip of land." That was the moment I decided I wouldn't argue. I would document, file, and finish it the legal way. My name is Matthew Doyle, and I live in a 2-story brick home just outside the boundaries of Willow Creek Estates, a neatly manicured suburban development outside Columbus, Ohio. My property sits right at the entrance of the subdivision, but technically, legally, it is not part of the HOA. The original developer sold my lot before the Homeowners Association was formally established. That detail matters more than most people realize. To the HOA, however, details were optional. The Willow Creek Homeowners Association prided itself on order. Identical mailboxes. Approved paint colors. Grass trimmed to regulation height. Decorative shrubs selected from a list. It looked perfect from the outside. But perfection often hides entitlement. The HOA president, Denise Harper, embodied that mindset completely. Early 50s, sharp haircut, always dressed like she was running for city council. She treated bylaws like scripture and assumed proximity meant authority. And unfortunately for me, her favorite shortcut to the clubhouse ran directly across the edge of my front lawn. I noticed the damage on a Monday morning. 2 muddy tire tracks cutting diagonally across my grass. At first, I assumed someone had misjudged the curb during a delivery. It had rained the night before. The soil was soft. I repaired it and moved on. 2 weeks later it happened again. This time I saw the vehicle, a white Lexus SUV with a small HOA placard hanging from the rearview mirror. Denise's car. She had cut across my property to avoid waiting at the entrance gate. I approached her calmly. "Hey, I think you may have accidentally driven across my lawn." She gave me a tight smile. "It's common access land," she said. "It was always intended as overflow space for the subdivision entrance." I blinked. "No, it wasn't. I own that strip." She waved a hand dismissively. "We'll check the plats." That was her way of ending conversations. After the third time, I left a note on her windshield. "Please do not drive on my lawn. This is private property." She came to my door that evening. "You don't need to be dramatic," she said. "It's just grass." "It's my grass," I replied. Her smile disappeared. "Your property borders a community entrance. That makes it community impact land." That phrase stuck with me. Community impact land. It sounded official, legal, almost legitimate. It wasn't. I ordered a certified boundary survey the following week. Bright orange flags marked the property line clearly, well beyond the tire tracks. The surveyor handed me a stamped document and said, "No easements. No shared access. This is yours." I installed small decorative stones along the border as a subtle deterrent. Denise drove over them 2 days later. That's when I realized this wasn't about convenience. It was about control. Denise didn't like that my home sat outside her authority while still benefiting from the subdivision's aesthetic appeal. In her mind, if I enjoyed the view of Willow Creek's clean streets, I owed them compliance. She began sending letters, official HOA stationery, claiming my landscaping violated community visual standards. I wasn't in the HOA, but she mailed them anyway. Then came the warning about unauthorized driveway modifications. I had replaced cracked concrete with pavers. Perfectly legal. Perfectly permitted. None of her business. I installed 2 discrete security cameras facing the front yard. Within a week, I captured clear footage of Denise deliberately cutting across my lawn, looking straight ahead, no hesitation. Not an accident. Intentional. I saved every clip. I photographed every tire mark. I kept every letter she sent. I stopped arguing. I started building a case. When I walked into attorney Rebecca Langford's office, I expected skepticism. Instead, she smiled the moment she reviewed the survey and footage. "She's trespassing," Rebecca said plainly. "Repeatedly. And she's using HOA letterhead to harass you." We drafted a formal cease-and-desist letter. It cited property boundaries, Ohio trespass statutes, and potential civil damages. Denise ignored it. She parked on my lawn the following Saturday. Rebecca didn't hesitate. We filed for civil trespass and property damage in county court. Small claims would have been easier, but this wasn't about convenience. It was about clarity. When Denise was served at her own HOA board meeting, the reaction, according to a neighbor, was explosive. She claimed it was retaliation. She claimed I was anti-community. She claimed she had implied access rights. She had none. The courtroom was smaller than I expected. Denise arrived with 2 board members. I arrived with documentation. Video footage played on a monitor. Clear as day, her SUV crossing flagged boundaries. The judge leaned forward. "Ms. Harper, are you aware this property is not part of your HOA?" Silence. That silence said everything. The ruling was straightforward. Cease all entry onto my property immediately. Pay damages for lawn repair and landscaping stones. Reimburse legal fees. And most importantly, acknowledge on record that the HOA had no jurisdiction over my land. Denise's face hardened as the order was read. But it wasn't over yet. Because of repeated violations, even after notice, the judge granted a formal injunction. Any further trespass would trigger automatic fines. Future violations could escalate to contempt of court. Now it wasn't personal. It was enforceable. News of the lawsuit spread through Willow Creek quickly. Homeowners began asking questions. Had Denise overstepped elsewhere? Were HOA letters always legitimate? The board called an emergency meeting. Denise defended her actions as protecting community standards. But homeowners don't like paying legal bills for someone else's ego. Within months, a review of HOA enforcement practices revealed selective rule application and unauthorized warnings issued to multiple non-HOA properties bordering the subdivision. I wasn't the only one. I was just the first to fight back. Denise resigned quietly 3 months after the injunction. No apology. Just a short statement citing personal reasons. The new board issued a clarification letter to all residents outlining strict jurisdictional boundaries. Clear, concise, legal. I reseeded the damaged grass that fall. It grew back thicker, stronger. Like most things do when pressure stops. I installed a low decorative fence, not out of anger but definition. Boundaries are healthiest when visible. Friends asked why I didn't just block her car in. Why I didn't escalate emotionally. Because anger is temporary. Court orders last. I didn't want revenge. I wanted recognition. And recognition requires documentation. HOAs exist to manage shared property, not absorb private land by proximity. Authority doesn't expand just because someone is confident. It expands only when unchallenged. I should have known Denise wouldn't go quietly. 2 weeks after the injunction, I received a certified letter, not from her personally but from an attorney representing the HOA. They were requesting mediation regarding shared access implications at the subdivision entrance. Rebecca laughed when she read it. "They're fishing," she said. "They're hoping you'll compromise and legitimize what they lost in court." We declined. But Denise didn't stop there. She began telling residents that my lawsuit had increased HOA insurance premiums. That I had cost the community money. That I was the reason dues might rise. It was strategic. Shift blame. Regain influence. Unfortunately for her, the court record was public. And homeowners started reading it. The next HOA town hall meeting was standing room only. Even though I wasn't a member, several homeowners invited me to attend. Denise stood at the front, posture rigid, explaining rising administrative expenses. A man in the third row raised his hand. "Isn't this because you ignored a court injunction?" Murmurs spread. Another homeowner spoke up. "Didn't the judge say we had no authority over his land?" Denise tried to redirect. But once people start asking the right questions, control slips quickly. For the first time since I'd known her, she looked uncertain. One of the board members, quiet, analytical, requested full disclosure of enforcement actions over the past 2 years. Emails surfaced. Denise had sent warning letters to 3 other properties outside HOA jurisdiction, hoping no one would challenge her. She'd approved minor fines without formal votes. She'd even referenced my lawn in internal emails as future leverage. That phrase didn't help her case. When the HOA's insurer reviewed the judgment and injunction, they issued a formal warning. Any future intentional trespass could void coverage entirely. That terrified the board. Without insurance, the HOA couldn't function. Suddenly this wasn't about grass. It was about financial survival. Despite the injunction, Denise's SUV appeared one more time, this time partially on my property during a landscaping inspection near the entrance. The camera caught it. Clear. Undeniable. Rebecca filed a motion for contempt. Back in court, the judge was less patient. "Ms. Harper," he said evenly, "a court order is not a suggestion." She was fined personally. Not the HOA. That distinction mattered. Word traveled beyond Willow Creek. Local Facebook groups picked up the story. Then neighborhood blogs. Then a regional property rights forum. The narrative wasn't complicated. HOA President ignores court order. People don't like officials who think rules apply differently to them. 3 months later, a formal motion was introduced to remove Denise as president. The vote wasn't close. She remained a homeowner, but lost authority entirely. A week after that meeting, her house went up for sale. The entrance to Willow Creek looks the same as it always did. Manicured hedges, stone signage, polished sidewalks. But the traffic stays on the pavement now. My lawn remains untouched, green, even undisturbed. I learned that some people mistake position for power. That wearing a title doesn't expand your legal rights. That politeness without boundaries invites escalation. But I also learned something better. Documentation beats confrontation. Patience beats pride. And the law, when used correctly, levels the field. The last time I saw Denise's SUV in the neighborhood, it was being driven by a realtor showing the house to prospective buyers. She glanced toward my yard as they passed. No anger. No shortcuts. Just a straight line down the asphalt. The strip of grass she once dismissed as community impact land now stood as something else entirely. Proof. Proof that boundaries matter. Proof that ownership isn't theoretical. And proof that sometimes the most powerful way to end a conflict isn't with shouting or revenge. It's with a court order, a quiet lawn, and a line no one crosses again.